Hi, my name is Greg Port and my law firm is called Port Legal. Today I'd like to talk a little bit about how we can avoid probate. When a loved one dies with or without a will and there are assets to be distributed to the family, in most instances a filing with the local probate court needs to be made. The probate process can be expensive, complicated, and take quite a while, and everything involved in the probate process is public record. To avoid probate, a person or a married couple can put their assets into a living trust. A living trust is seen in the eyes of the law as a separate entity, so after one passes away, that entity still exists. The price of a living trust is going to obviously vary upon your exact situation, but you're looking at anywhere from $1,500 to maybe $2,500, $3,500. When you're looking at probate, you're probably starting at around $4,000. It's going to go up from there. The cost of probate can be double or triple or even quadruple the price of setting up a living trust. If there's a living will, you will avoid all those costs. With a living will, you'll have some upfront to establish the trust, and then after you pass away, there's several documents that have to be created, but those are relatively easy to create, and you're looking at hundreds of dollars compared to thousands. The ideal situation is to put everything that you have into your living trust. So your checking account, rather than saying Bob Smith, will say Bob Smith, trustee. The deed to your house, rather than saying Bob Smith, will say Bob Smith, trustee. It's that simple. If you've set up a living trust with you and your spouse, upon your passing, immediately becomes the sole trustee of the trust, and everything operates as it was before. If the second of you passes away, then the successor trustee is usually going to be one of your children. If you have minor children and you happen to pass away, your living trust is going to provide for a guardian who's going to take care of your child, and that guardian will be duty-bound to preserve your assets for the benefit of your child. Now, a trust is similar to a will in that you will make provisions on where your assets will go. Are they going to children? Are they going to other family members, brothers, parents, things like that? So anything that you could take care of in a will, you can also take care of in a trust. Ultimately, what's most important is that we take burdens off of our family. We pre-plan for funerals, we write wills, we create trusts. Most people may not think about is that you want to take off the burden of probating off your family. If you're considering a living trust and think it may be best for your situation, the best thing is to consult with attorneys and have a no obligation meeting and discuss your issues, your exact situation, and what they can do for you. At Port Legal, we're always open to free consultation. Feel free to call us and drop by and discuss these things with us at any time.